South Africa's justice system faced a defining week that also continues with the Madlanga Commission resumed hearings with senior officials trading allegations under oath. There's a judicial misconduct ruling in the Mbenenge case that does reopen questions about power and accountability on the bench. Conduct of NDPP Shamila Batohi that also remains under scrutiny. And of course, in the Free State asbestos case, Moroadi Cholota has entered a critical plea phase. But at the center of all of this is, can the law hold its own institutions to account? Let's unpack this with legal journalist Karyn Maughan. Karyn, good morning and thanks for joining us at this hour.
Thanks for having me, Liesl.
Oh, it was a busy week to say the least. And I'm just looking at the Madlanga Commission and the legal weight of the testimonies we heard from Major General Anthony Gopal, as well as Lieutenant General, about Lieutenant General Nhlanhla by Lesetja Sinona. Some narratives, some conflicting narratives, some intersections as well that, look at personal relationships, conspiracies as well. Can you give us a summary of what happened this week and what fresh legal issues are then likely to arise in this phase two?
Well, there are two separate issues. The first phase of the commission was really dealing with, evidence that quite profoundly implicated the suspended police minister, Senzo Nkunu, and the auspices of the topic of political interference. And of course, the allegation is from those witnesses, including Gopal, that the then minister had used his position to effectively delegitimize a MKP candidate in an election where the ANC was contesting a ward. And of course, we know also there was another witness, Witness E, who claimed that the minister had put him under considerable pressure to testify at the commission and sort of do so in ways that disparaged crime intelligence head Dumisani Khumalo. Now, we know, of course, Nkunu has denied that. He'll be asked to address it. But I think some of the more explosive evidence came with the KZN Hawks boss, Lesetja Sinona, who, it has to be said, was very much not someone whose testimony appeared to be accepted in any great detail by the commission and the commissioners, where there was very vociferous questioning from DCJ Madlanga, from Commissioner Sesi Beloy, and from Commissioner Sandile Khumalo, who, with Madlanga, essentially saying that he did not buy Sinona's claim that his quote-unquote brotherly friendship with Vusi Musi Pat Matlala, the tenderpreneur, that he had tried to distance himself from that, highly implicated, now attempted murder accused tenderpreneur after he read a News 24 article on the 5th of March 2024 that 2025 that implicated him in significant wrongdoing, including the fact that he was under investigation for the attempted murder of his ex-lover, Teboho Tobojane. And Madlanga making it very clear to him that he simply did not believe him. Of course, some of his more explosive evidence supporting Matlala's testimony to the ad hoc committee that is tasked with investigating Nhlanhla Nkwenazi's allegations of criminal infiltration, saying that, in fact, Nkwenazi had met with Matlala and, according to Sinona, had offered to row back on that investigation against Tobojane if he gave evidence implicating or gave information implicating Deputy National Commissioner Shadrack Sabir. Of course, we know, Liesl, that on the messages that were exchanged, Nkwenazi says that he has an audio recording of that meeting, and he will play it at the ad hoc committee and very also likely at the Madlanga Commission itself.
Yeah, Karyn, it's speaking to now timelines as well, because testimonies that point toward collusion or interference by senior law enforcement officials, it's going to be shaping the Commission's recommendations and trigger disciplinary prosecutorial action. I'm saying this because the scale and the complexity of this alleged criminal network, it's a mammoth task. And so this also comes with legal challenges that phase two is going to be faced with, particularly when it comes with verifying networks, tracking these financial flows, uncovering some of the conflicts of interest as well. What are we in for?
Well, I think you raise a very valuable point because, at this point, there was a lot of hearsay testimony. There were a lot of, for instance, that were attributed to Matlala by some of the undercover, unnamed police officers who've been very involved in the investigation. There has been a lot of very strong evidence, prima facie evidence on the findings of the interim report of the commission, where they've named, amongst other people, Lesetja Sonona, Julius Mkhwanazi, the EMPD, deputy head, Imogen Mashazi was the head of the Ekurhuleni city manager, Robert Shabiri, who was in charge of the investigation into the murders of the father and son who were gunned down. But there obviously is a wariness, because two of the big names that we didn't see on that list, and it really speaks to the issue that's being addressed in the Sunday Times today, were, of course, the minister and, of course, Shadrack Sabir himself. And given that the commission was prepared to make those interim findings and interim recommendations for investigations against Sabir and against and not against Sabir, but against a wide range of other officers, but wasn't prepared to do so against Sabir, may have a lot to do with the fact that, yes, he hasn't testified, but a number of people on that list haven't testified either.
Yes.
So it has to be about essentially the commissioning wanting to nail down the kind of sustainable prima facie evidence, not just hearsay, not just people saying people said, but actual hard evidence of what he's potentially alleged to have done.
And Karyn, in addition to the named witnesses as well, and some question marks about who still has to return, I mean, the commission also expected others, such as Sergeant Fani Nkosi, to obviously arrive as well. That testimony postponed this week. The delays from, these testimonies, potential key witnesses, how does this all affect the pace, the coherence of the legal inquiry at large?
I think you raise a very important question, because we have entered the phase, Liesl, where implicated officials are now testifying.
Yes.
So these are people who are in the second phase of the commission's life, who have to address the evidence against them. And of course, one of the most foremost in all of this is Shadrack Sabir, who of course is, we know, alongside Mkhunu, the subject of a separate criminal investigation. We know that because certain devices were seized, and there was, at the beginning of the life of the commission last year, there were certain legal issues that unfolded in relation to that. But, all of these people, Sonona came, he has expressed unhappiness over what he said was, problematic provision of evidence to him. But we are going to see a more contested space here, because this isn't a scenario in which you have the police officials who say, we are aware of very damaging allegations, we want the opportunity to ventilate this issue. You now have the people who are on the other end of that, who in many instances, based on the WhatsApp communications, particularly of Matlala and others, have been implicated in quite serious wrongdoing, who now have the chance to respond. So I don't think we are going to have an easy road here. And I think the commission is trying to balance that in fairness to the witness whose name we are now not allowed to utilize, in respect of the so-called white bag that he received at Katiso Malefe's house. Of course, Katiso Malefe being the tenderpreneur, the businessman who has been arrested for the murder of engineer Armand Swart. So we are going to enter a contested space, and I think we're going to see a lot of to and fro. And so, I think it's very likely that the commission's life may well have to be extended, and we've seen hints of this already from the commission itself in terms of this last week's hearing.
Karyn, speaking about contestation, another case where we're looking at judicial accountability, Mbenenge sexual harassment misconduct tribunal case. Perhaps you could talk to us a little bit more about the ruling the Judicial Conduct Tribunal made this week, the composition, the tone, the precedents, the set, the panel as well. We're obviously looking at the difference in legal terms when it comes to sexual harassment and findings of misconduct at large, the implications as well.
Well, Liesl, this does have big implications, because this was the first time in South African judicial history that, in history generally, pre-democratic, post-democratic, now democratic, where the Judicial Service Commission has taken a judge into an inquiry to investigate allegations of sexual harassment. And so, everyone was watching it very keenly. We know that the Secretary, Andiswa Mango, had waived her rights at confidentiality, that it had initially supposed to be a closed hearing. There was initial great reluctance, given the nature of the allegations, for this to be ventilated publicly, and it was ventilated publicly. And now we have the outcome that essentially Judge President Sylvia Mbenenge has been found not guilty of impeachable gross misconduct. He's been found not guilty of sexual harassment, but he has been found guilty of a lesser charge of misconduct, in that on the findings of this panel, he sort of instituted or attempted to pursue a flirtatious relationship with a much younger High Court Secretary, Andiswa Mango, whilst in office as a judge, in a way that potentially undermined his oath or his accountability to act, above reproach as a judicial officer.
Yeah.
And there's been no sanction recommended by that in this process. But also, and this is going to cause a great deal of commentary, and I think, understandably and importantly so, there were very adverse credibility findings made against Andiswa Mango. This panel has essentially said that she lied because on its findings, she did not admit that she had copied aspects of her first statement to the Office of the Chief Justice in her second statement, and they found that was an adverse reflection on her credibility, and they went into the details why they said that. And they also said that she had deliberately omitted certain more flirtatious messages, and what they described as salacious messages that she'd sent to Mbenenge when she made her complaint. And they said that, that her lawyers have essentially argued she played along with the judge president because he was so much more powerful than her, and that she was essentially afraid of the professional implications for her as a single mother if she didn't play along. They've rejected that. They've said this issue of power dynamics is immaterial, and that essentially she is a liar and cannot be believed, and therefore her evidence that Mbenenge sent her images, that he tried to solicit oral sex from her, that must all be rejected.
Karyn, Time is unfortunately not on our side, but obviously we're looking at the, what happens with the tribunal. Now the report has been issued, of course, and what appeal prospects are as well. But I'm going to have to leave the conversation there. We'll continue to monitor those developments as they continue in the public domain. These cases, as you've heard, are not just about individuals. They are about trust in the justice system itself. And so as the commissions, as the courts, as the inquiries continue, the country is obviously watching how the law responds. Again, thank you to legal. It's Karyn Maughan for joining us here on this Legal Matters segment, just unpacking some of those big cases as well.